who are up on appeal on re-exams. This case here, if you haven't seen it. And then, of course, the last case I mentioned earlier is the case that was decided yesterday, the construction equipment case, which I urge you to read as well. So I'm done with a minute to go. Thank you.
Great. Thank you, Rob. Maybe we can get the next two speakers down here quickly. We have a lapel that Rob has, and we have another lapel mic here that we can connect. So we have Justin Nessel from the local Sussman Godfrey office, and Mingyao Tan from Finnegan in San Francisco, and they're going to talk to us about the changes to patent litigation based on the Act. That one too. Do this first.
Well, that gets set up. We decided to try to do it a little more back and forth. Ming represents, both of us represent plaintiffs and defendants in litigation. Ming does it more on the defense side, and I do it more on the plaintiff side. But hopefully, together, we can bring a perspective of what it's like both from the plaintiff side and from the defense side about how the AIA is going to affect patent litigation. Ming?
Yes. Okay, so Justin and I were going to talk about sort of the impacts we see as coming from the AIA on many different issues in litigations, and this is a summary of what we will talk about, the impacts on PTO and ITC practice, and also there, because some new defenses are added, some old defenses are eliminated, we'll talk about the complexity, the cost, and also how does the new statute impact the discovery? And I think oftentimes whatever takes place or happens in litigation also affect how people conduct licensing negotiation, how people conduct settlement discussions. And I think throughout the discussion of different issues, we'll address that as well. And feel free to interrupt with questions. I know this is an area that is going to create a lot of uncertainties, and also there may be many different perspectives from all of you about how the litigations may be affected.
Yeah, please, we all want to make it interactive. I told Rob that I was going to call on him just as much as he called on me, and then he promptly left the room. So hopefully we'll get more audience participation as well.
So let me talk about just the complexity in general. As you all know, FITF applies to patent that has the effective filing date of March 16, 2013. So going forward, I think all of you can foresee that you'll be litigating patents under both regimes for a long time. And I did a little bit of illustration on both prosecution and litigation, and I think many other speakers have talked about the prosecution side of it, and Judge Tini has done many different hypotheticals illustrating that when different priority dates were claimed or when different events occur, you may be falling under the old first to invent system or under both systems or exclusively the new system. And I think what is more interesting is just thinking about what will patent litigation like? Not in year 2013, but in year 2033. Believe it or not, I think Justin agreed with me too. Even in year 2013, you'll still be litigating patents that are governed by the statute under the old regime. And just to talk about, for example, for the cases that are being litigated right now, of course, those patents were issued under the old regime, and you'll be conducting your litigation under the old regime. But even after 2013, most of the patents that will be allowed under the new regime won't be available soon after 2013. Will be maybe 2014, 2015, and I know PTO, of course, will be issuing patents a lot quicker than before. So for litigation between 2013 and 2033, depending on what patents you have in a given case, you may have to deal with both regimes. And the reason why that is significant is there are so many different issues in there. You have different scope of discovery because prior art apparently is very different. You will have the ability to argue prior user rights, ability to argue derivation for some patents, but not necessarily other ones. And in terms of the best mode, as you can see, the new regime will prevent parties from litigating the best mode issue. And so what is interesting is, I think for most people in the room, I think the old regime is still going to impact us for a long time, but the new regime at the same time will bring a lot of interesting challenges to litigation.
Let me just say one comment on that. There's someone had mentioned the Federal Bar Association, CLE, earlier this week, and the panel included a Ninth Circuit judge, Judge Fletcher, and then Judge Lasnik. And Judge Fletcher said the one thing that he felt very, very strongly about and would be absolutely opposed to would be if Congress ever tried to change the law to make anyone other than Federal Circuit appeals judges hear patent cases. And Judge Lasnik then piped in and said that he wished he could change the law that he could get rid of a patent case at the drop of a hat. And I think the complexity that we're going to see in these dual regimes is only going to increase the tendency of judges who might not otherwise be inclined towards patent cases to shy away from it, given just the mix of regimes. Perhaps we'll see the patent pilot program help in this respect in some of the districts, and maybe we'll see more push by Congress to make sure that in the Article 3 context, the judges who are hearing patent cases are the ones who are doing it more by choice as opposed to what they see as getting the short end of the stick. And so because of that, I think, and it always concerns me, as I know a lot of you are prosecutors, and as a litigator, it's always a little bit daunting to talk to a room full of prosecutors. But from the litigation side on discovery, we're looking at a regime here that, at least on the defense side, you can expect the arguments to be, well, look, and I know y'all talked about this earlier today, where because the new prior art can be anywhere in the world, we've got to go over the world, and we've got to use the Hague Convention and other ways to get that discovery, and that just takes time. And we're going to need more time. And I can pretty much guarantee what both parties are going to say in that, or the plaintiffs are going to say, there's no reason to have more time, let's do it on a particular schedule. And, Ming, I'm sure some of your clients will say something different. But I think regardless, especially with the complexity that's inherent in these dual regimes, at least for the foreseeable future, you're going to probably see some increased cost, potentially some lengthy discovery, although that's going to come back and forth between what the district court does and how long that judge wants it on his or her docket, and the impact on the case schedule. Are we going to see, for example, more stays pending re-exam when all this is going on, when the judges, especially judges who might not want to have some patent cases on their docket, are they going to use it as an excuse to stay, especially given perhaps the shorter time periods for the PTO re-exams? And so then, of course, there will be discovery to assess the exceptions to the prior art for disclosures and what that means and whether it is actually prior art, which are some real important changes in the Act. And then the prior commercial use defense. Again, these are, I think, changes that we're seeing that every single one of these is going to be an increase in cost about how we can try to litigate it in the most effective manner and how to give both sides their due process rights in it. And how do we litigate otherwise available to the public? I think that is certainly a big unknown question about how we're going to be litigating that, what exactly that means.
So in terms of best... Okay. Okay, so on BESMO, as other speakers have talked about before, there is still BESMO in the statute, and Keith mentioned this as well. I think it is correct, and I agree with Keith, that the best corporate practice is because there is still a requirement in the law. It's still better that you comply with the statute, but in terms of litigation, it will no longer be, or it's actually no longer a defense to invalidate a patent or try to render it unenforceable because of inequitable conduct. But the big question to a litigator is, and maybe to many of you in the room, despite the fact that you can no longer invalidate a patent or render it unenforceable for reasons, for failure to disclose BESMO, are you still entitled to discovery about it? Can you still tell a pretty good story on the defense side to say that, well, there is a requirement in the statute and the inventor or inventors were aware of the BESMO of practicing the invention and chose not to disclose it in the spec? And it's still, I mean, of course, it's going to subject to motion in limine, and litigators will try to keep the story out of the courtroom. But my personal feeling is that it's very similar to what people have been talking about under Saracens. There is a tightened standard under Saracens. People know that inequitable conduct is really hard to meet, I mean, in terms of trying to establish or prove your case. But it doesn't really prevent people from telling the story, doesn't really prevent people from getting discovery conducted on issues like this. So I think the impact on litigation is that, yes, it's removed as one of the defenses, but it might not affect how people proceed with their cases and how people proceed with their stories at trial.
This is, I'm sorry,
yes, sir.
I was going to say this is an area where Ming and I vehemently disagree on. I think that what the statute says is what it says, and that I think judges are not going to be sympathetic to taking discovery on a defense that is not effective. So I'm sorry, but yeah.
So I guess I see that you can't use it as a basis for invalidating or rendering unenforceable, but I'm wondering about injunctions and other relief that is equitable in nature. So it would seem like you might still want to say that there's an unclean hand that comes out of this failure to disclose. It doesn't render the patent invalid or unenforceable, but would be used to argue against an injunction. You still have remedies at law because of the difference between equity and law.
I think my initial reaction on that is, although the Saracens decision does still provide sort of the open door for people to challenge in exceptional cases, sort of like fraud on the patent office and on clean hands. But I think because Congress has provided definite statement on this issue, I don't think you can try to backdoor the BESMO argument by some other sort of different terms. That's just my...
That wasn't my point. My point was that in terms of the remedy, because of the fact that injunctions are, one, already being weakened in their applicability where there's adequate remedy in law, and then the fact that there is an equitable component to injunction because they're an equitable remedy. So it wouldn't necessarily, you say the patent's enforceable, but only for legal remedies, not for injunction.
I see your point, and it would be a defense to injunctive relief, right? I mean,
That's my
look, I think you can make that argument. I think that, look, if we're putting on our speculator's hat here, I think it's unlikely to be successful because I think there is the clear language in the statute, and I think that the judge is going to not want to necessarily get into it. And I think to use that, if assuming that you meet the other 4 criteria for either a preliminary injunction or a permanent injunction, and to say that, well, yeah, you meet all those other 4, but you don't comply with best mode, so therefore you don't get an injunction, seems to me to be a pretty unlikely set of scenarios. Yeah,
So does that mean an applicant can knowingly conceal the best mode, commit fraud of the patent office, and there is no consequence?
Rob?
Let me just say that I've heard presentations that by inequitable conduct people, experts, who believe that this is a trap for the unwary, and that it is going to be litigated hard and in front of a district court judge. Who knows what's going to happen? And so I think as I said earlier, I think it's just a shame that they should have either gotten rid of it or not gotten rid of it. I don't get it.
Yeah.
I have to believe it's going to be paid to someone very commercial body that is pre-released eyebrow, and they potentially did the commercially viable product. You know, we all know what patents is really for. Give up your secrets, disclose them to the public. It's in front of that, and we'll get a secret.
Yeah, look, I think you're right, and I think that on the sort of to combine the 2 comments here, I think there really could be something where you use the failure to disclose best mode as a basis for unenforceability. But again, you're coming up against the Theracense law of you know, what do you need to get over the hurdle to prove inequitable conduct? And if it's not going to be a basis for validity and unenforceability, then what do you do with that? So it's a very difficult dilemma. Yeah?
Do you use it to show discredibility of the witness or the other side by showing that they intentionally failed to meet their statutory obligations, even if the validity itself is no longer an issue? They were required by the statute to provide it. They didn't provide it, therefore how can you trust it?
Well, like all of us learn on the first day of law school, the answer probably is it depends. And I think it primarily depends upon what district court judges will let you get away with, right? I don't think in most courts that you're going to get away with an argument like that, but especially those that don't allow those types of equitable defenses to be presented to a jury in the first instance. But there very well may be some where you're going to get a more receptive audience from some district court judges. Yeah.
Equity does not demand that the suitors that they shall have led blameless lives. That's the case involving the blobs of glass going back to the 1930s. Just proving that the other side has done something that is bad, they're bad people, doesn't get you necessarily to the result you want at the end of the day. And you're just saying they're bad people because they didn't disclose the best mode. But if that's not a defense, so what?
Yeah, I mean,
he cheats on his wife too. So what?
I mean, yeah, I mean, obviously the other side is going to object on Rule 401 and 403 on relevance grounds and on prejudicial grounds. And so, you know, I tend to agree with that look, I mean, you could get, especially because it has not been completely removed from the statute, I think a lot of district court judges are going to say, okay, I can't use it for invalidity or unenforceability, but maybe there is a story to tell. And I think, look, for trying to say what is the better of the argument, I think it's probably irrelevant or at least unduly prejudicial, but some judges might feel the other way. Other comments? Yeah. Yeah. Others?
Just
Yeah.
the back room here is about 50% of what's discussed up front.
Oh, okay.
And none of what was just said.
Oh, fair enough. So let me repeat the question then, and that was that for Section 112 grounds, you still have to have, for priority purposes, best mode, and so perhaps for priority purposes, it comes in for that. If I can summarize. Oh, sorry, yes.
Just a simple question. I mean, this is an obvious issue when you write a statute. And if you take out a defense and you still have a statutory requirement there, there's probably going to be this discussion. Does anybody have any kind of insights as to why? Was this discussed in the drafting? And was there was it a compromise where, I mean, what's going on behind the scenes? This is an obvious. Was this just a mistake, an oversight, or was this some sort of a compromise and people just didn't want to do it and just kind of threw it?
Well, I see the people who are actually most heavily involved in the drafting shaking their heads saying, I don't know. But yeah, go on.
I have knowledge, but I have a patent AO. There's a blog site, Patent AO, which had an article written.
Speak up a little bit so everybody can hear you.
Patent AO had an article several months ago by a person I have no knowledge of. He said he was in the discussions and that was actively discussed and that they came up with this scheme. I can't remember the rationale for it, but if you want, I'd search that blog site, Patent AO, best mode, and it's probably 2-3 months ago if anybody else had read it.
Yeah,
Yes.
I remember.
Yeah, but I was skimming through it. I've been busy, so I don't recall details. Sorry.
And one interesting question is, I think, although that defendants are prevented from raising this issue in court, does the statute prevent the patent office from taking on the issue during the proceedings such as supplemental examination?
Or a post-grant review.
Yeah.
Yeah, please.
Here's a quick answer. For petitions, the petitions to the office for inter-party reviews, post-grant review, business method. There's certain things that we can look at. For inter-party review, it's patents and print publications. So, PGR is for 282B2, B3. Those are 101, 102, 103, and 112. But 282B, I think it's 3, if I'm correct, says we're not, invalidity, you can't invalidate a patent based on best mode. So they've basically taken that, which you can't do in this court, and put it in our jurisdictional, what you can file a petition on. So, take away what you will, but my read on it, best mode would seem to be not a basis for filing a petition. We don't have any specific cases if we have one yet. But if you read it, it does not appear to allow the best mode.
Well, I mean, the question that I would ask, how would you even know if the best mode hadn't been disclosed at that stage in the process?
I'll just tell you a quick anecdote. When I was on the outside, the office does examine for best mode. All right, but how often does the office realize there's a best mode problem? It doesn't. That's one of the oddities of the practice. However, when I was in private practice, I had the unfortunate situation where we filed a Japanese translation for specification. We got a few formality requirements saying we don't understand these terms, can you explain? Our office decided, well, let's just fix it up, get a better translation. We submitted the better translation, certified copy, addressed all the rejections on the claims. Next thing came out with the best mode rejection. To this day, I don't know why we got best mode. I called the examiner and said, this is a translation, it's the same specification we translated. And it took me quite a while to get the examiner to understand that best mode does not pertain to just getting a better translation.
No comment. Any other things on best mode? Yeah.
Well, the other way that they'll find out about it is where the companies work together at some point, the derivation cases.
Yep.
And Company X used to be friends with Company Y. They're not friends anymore. And Company X says Company Y failed to disclose the best mode, and I know what the best mode was, and I know that they knew, and here's the evidence. It becomes filling out.
Yeah, there's a comment in the back.
Is that the article by Shepard? And I just Googled it for you. The rationale is they took out the best mode enforceability aspect because they didn't want to have people have to put in best mode anymore. Congress left in the requirement in Section 112 so that when the public complains the disclosure is now crappy, they can say, hey, we still told them to put it in. That's literally the interpretation was provided.
Yet another. Did everybody hear that? The reason evidently was a CYA mechanism of Congress to say that when disclosures become not so good, they can say, well, you still have the requirement, even if it's not enforceable. So chalk that up as another wonderful lesson and result of the AIA. Other comments on that? Yeah, in the back.
A constitutional law argument based on, so the way I understand Article 8, Section 8, the drafters contemplated a quid pro quo for disclosing, enabling an invention. The inventors get a monopoly for a given period of time. But if best mode isn't there, have they actually disclosed it to the public?
It's a really good question, and there is certainly some Supreme Court case law like Bonito Boat that talks about that specifically. I think that I don't see it quite being successful, but I think it's worth a try. The problem is, of course, from the constitutionality of the argument. Did everybody hear the question? The question was, is there a constitutionality challenge because the whole idea of giving a patent monopoly is to the disclosure, the quid pro quo, to understand what's going on in the actual disclosure, and that's why you get a patent monopoly for a limited time. And does the best mode take away that? I think that because of everything else that you still have to disclose as part of the patent application, that you're not doing it as a trade secret, that's probably going to be sufficient at least to get over the constitutionality issue. Good question.
Okay, so moving on to another defense that has been eliminated by the new statute, or at least there is some way to cure what have occurred during the prosecution. You have the supplemental examination process under which a patent owner can ask the PTO to consider, reconsider, or correct information believed to be relevant. So one example would be prior art not previously submitted or considered, but there is a restriction that this must take place before the assertion of inequitable conduct in litigation. And also, patent cannot be, once the supplemental examination took place, patent cannot later be held unenforceable because of the certain information not previously disclosed in the initial prosecution of the case. So this does provide patentee the perfect opportunity to fix any potential issues they see, and also give us registered patent agents a way to keep out patent registration numbers.
I'm going to have a prediction here on this section. It's going to have minimal, if any, effect. I don't think there's going to be that many filings. I could be wrong, but the reason why you do this is to fix something right before litigation. When you're looking at it, when you go to your litigation counsel, and look, a couple years ago we've had cases with this exact same thing came up. We saw it, and the lawyer was supposed to disclose something. The lawyer didn't disclose something, and we did an ex parte re-examination and fixed it to make sure that the art that was supposed to have been disclosed got disclosed. The issue, I think, now, post-Therosense is that really going to happen? I mean, is there really going to be a case where, and maybe there will be, where the art is so close on a materiality standpoint that you would want to take the risk of putting it into a supplemental review that very well might delay your enforcement program by a couple of years? Or are you going to say, look, yeah, there's a risk of invalidity, but the risk of inequitable conduct is no more than the risk of invalidity. And so therefore, might as well go and proceed. We have good arguments about why the art that wasn't disclosed does not render it invalid as anticipatory or obvious. And so if that's the case, then maybe we just take our chances in litigation on the underlying validity of the patents and see where the inequitable conduct jets fall. Yeah?
I have a comment because I think you're right in that regard. I've thought about this concern. Recent case law tells prosecutors to be very nervous about not fully vetting species, not fully treating the light of the generic claim terminology. It's a great risk, not knowing the prior art that you're going to eventually see. You go down a path where you're ignoring your commercially viable intention.
Yeah. Yeah.
The difference between validity and fraud, unenforceability, is the personal career of somebody is at risk when there is any kind of an unenforceability issue. And that somebody is very frequently deeply involved in the decision whether or not to file the supplemental examination. And if Larry Pope had had the opportunity to try to wash his conduct in the blood of the lamb by filing the supplemental examination, of course he would have done it, to the extent that the decision maker has his own personal rear-ended risk. There's a huge bias towards filing.
I think that's right, but I think more often than not, if it's a prosecution counsel mistake as opposed to an inventor mistake, more often than not, that prosecution counsel is not making the final decision about litigation. It's going to be the client, and it's going to be litigation counsel, maybe in conjunction with the prosecution counsel.
Larry Pope was a very, very senior in-house faculty.
No, I understand. I'm not saying it doesn't happen. Okay, I'm not trying to say that it will, there will never be a situation like that. But I think that there are also, more often, the case is that the issue that comes up on the inequitable conduct side, maybe they will say, well, look, I really want to protect my prosecution attorney and delay my enforcement program by 2 or 3 years if it comes up. And it's possible, but I think there's just going to be more a tendency to try to get it done quicker, because the way I think supplemental review works is that if they see an issue with the supplemental review, and if it's close enough that you're concerned about it to put it in, then you're back into re-examination proceedings, which depends. Maybe it's going to depend upon how long the re-examination proceedings are taking at that time. If it's really taking 6 months, less than a year, then maybe that's one thing. If it's taking as it is now, and there really isn't any material difference in terms of the length, then maybe it's a different story.
We have additional comments? Sir?
Yeah.
If you follow the model where you do friendly licensing and then litigate later on, wouldn't this be the normal process? You do your friendly licensing, collect all the art that everybody gives you, clean it up, and then hit the litigation? So wouldn't you almost always do it?
I think it depends on whether you can do, number one, friendly licensing. Oftentimes you can't do friendly licensing. But if you can do friendly licensing, I think a lot of this is what was going on during prosecution. So if there's a continuation, you can try to watch the art that they've given you through the continuation, but also put it in through there. But
I usually see the best art comes in during those when you're out trying to license it.
Right.
That's when you get a really good search. And so to me, that's the data you're going to be cleaning up, not so much something that's missed during prosecution. Not that it doesn't happen, but I just think you're also going to have a big pile of stuff like from your licensing, and you want to get something, you want to do something before you go to litigation.
no, that's
So
fair.
you would use this one, you're suggesting, not because as prosecution counsel you're concerned about inequitable conduct charge. You never knew this art existed.
Right.
But this might be the
This
quickest
cleans
way to clean
This
everything
cleans
up.
up a lot of the defense that the other side would be throwing at you, and you get it out of the way. And
To wash it through.
Yeah.
No, it's an interesting point. Yeah.
I don't know for a fact. All I've heard is the rumors that come through, and that is if you're buying a patent portfolio from whatever company, sometimes we've heard people say when they go to buy another corporation's patents, they will take whatever art that's been found and go into the supplemental examination just because they want to make sure the code is bulletproof. I take no position on it. That's just what I hear through the grapevine.
Yeah, I can see that in some cases there is enough justification to go through the extra time that you needed to go through this process. One is to really whitewash the prior references, especially the very good prior references identified by the potential licensees. And secondly, I think for companies that do see the previous prosecution as part of a big impact on credibility, I think there is reason to make sure that there won't be any inequitable conduct challenges once you file a litigation. So I think in some cases, I think there may be enough motivation for the patentees to do that. So I think we talked pretty extensively on this issue and talked also about the Saracens, and this is effective. This will be effective September 16, 2012, and I think some of the limitations we already talked about it, including that you can do it, you cannot do it if there is already an equitable conduct allegation in the litigation, and also if in ITC cases it won't be effective unless the supplemental examination is concluded before the ITC action filing. And again, there is another wrinkle to the filing of the request, which is if you have misleading or false statement in the supplemental examination request, this misrepresentation alone can be the basis for inequitable conduct.
And we talked a lot about this in the last session, which is the impact of post-grant reviews and PTO proceedings and how that's going to affect litigation. And I think that long-term, these changes certainly have the most effect on litigation, with the possible exception of the joinder provision that we're going to talk about in a few minutes. But the relationship between PTO proceedings and district court litigation has always been an issue. And it's become, I think, going to become even more so with the expedited proceedings. I think anyone who can say it's going to definitely lead to a shift to the PTO or not, it's too early to be definitive about this. And I think, frankly, it's going to depend a lot upon how well the PTO does in living up to, number one, how fast it does it, and number two, whether the process is seen as being fair. And those are still really open questions. And how it does it, given the limited resources still, I think we're all waiting to see what happens, right? No pressure. Yeah, Rob.
When you say whether the process is being seen as being fair, I think it's different. I think whether the process is being seen by third-party requesters as being to their advantage, not fair. I don't think fair has anything to do with it. If the process is slanted in the direction of the accused infringer, they're going to go to the patent office. Don't you think?
Yeah, but here's why I say fair. I think that's a fair point.
Thank you.
But I think that from the perspective of the litigators and from the district court judge about what the district court does with it, is if, for example, I think you are going to see, if it turns out to be a transparent, fair, quick process, I think even courts like the Eastern District of Texas, who sometimes don't stay for re-exams right now, you well might see more stays for re-exam, for example, to try to get that process done quickly. Whereas if it's not, and if it's sort of where we are right now, I think you're probably going to see the same types of stays versus not stays that you see today, where some courts stay and some courts don't, and then you're in this never-never land, depending upon which judge you have and what the PTO is doing and what the district court's doing. So I think that's where the issue of transparency, fairness, due process does come into it. But I think
couldn't you argue? I hope you're right, but couldn't you argue that all the courts are going to care about is whether the PTO can do it in a year? Couldn't you say, the judge will say, okay, how fast is it going to happen? Is the Patent Office being able to do this according to the statute? Is the Federal Circuit reviewing these quickly? Okay, we'll go with it. You get a stay, come back and see us in 3 years.
Once in a while, we do get a request from it. Once in a while, we do get a request from this court judge to give them a status of where we are on a case. And we know that that's being looked at. What our answer is going to be taken into account when they decide whether or not to stay the proceeding. Clearly, as you mentioned, it's no pressure at this time, right? But we understand that there will be potentially be a major impact on this court litigation depending on how these rules go out, how the parties are coming in, how we're resolving. If we get these things done in a year, we get the answers right, high quality, it'll go one way. If we don't meet our goals, we'll understand the consequences. So again, we raised a lot of great issues today. I just want to point out once again, please give us comments. We want to get this right. There's a little bit of pressure on the office to do this right the first time. We don't want to be here 5 years from now going, here are the list of problems that could have been corrected, but they weren't. So because they're pointing out all the things that can happen if we get it right, we really are trying to strive to put all the effort up front.
I'll bet you $1, okay? Then 5 years, we're still discussing this issue.
You can't do that. He's a government.
Oh, fair enough. Excuse me.
That's above the limit, right?
But on Rob's point, though, about, well, is it going to advantage or disadvantage the third-party requester? These estoppel rules really have bite, okay? And if it is quick, right, and if you're seeing a 1 year, 1.5 years, and all of a sudden, let's say even there's a 50-50 hit rate in terms of patents or some claims that come through. But then they're stopped from doing it, maybe it's 60-40, whatever that is, then is the third-party requester really going to take that chance, knowing that a lot of their leverage in district court litigation suddenly goes away if the patent survives the inter partes re-exam process. And I think that is, again, one of the great unknowns. I don't know if anybody has comments on this.
That'd certainly be a drastic change from the current standards, where I think there's 22 patents that have made through inter partes re-exam with all claims allowed, ever.
It doesn't. Why does it have?
An unbelievable death rate in the central re-exam unit. So that to think that you'll have a 50-50 coming back out of there in a 1 year process, I think is just unimaginable.
Well, look. Number one, it doesn't have to be all claims, right? If you get one claim, especially if it's a decent claim, you're off to the races. Number one. Number two.
Especially if it's a decent claim. Only if it's a decent
Well, of course. But number two. One has to think that if there are more protections, if they are doing a full-blown litigation or a full-blown proceeding within the inter partes proceeding, to take into account everything, that perhaps it will not be the death box that it has become in many instances in inter partes re-exam. Again, I think you're right that if it continues to be sort of you go to inter partes, you die, well, then you're going to see more of it. But I guess, it's an unknown whether that will still come up. So, yeah.
All I can say is when I was in Seattle in April of 2000 at the CLE, everybody that got up to talk about inter partes re-exam said it would be malpractice to file it because of the estoppel thing. And now that's not the view of the majority, I don't think. So I think litigators especially raise the estoppel thing because it's something that's outside the court and the processes of appeal they're used to. But if the outcomes are favorable, I think that's not going to reduce the estoppel risk.
Well, that's fair. I will tell a quick war story, which is I currently have a case here in Seattle that the district court has stayed for re-exam. There are both ex parte and inter partes petitions going on. The inter partes re-exam just came out. And so what's going to happen to that litigation? Who knows? But it's a lot stronger now than it was, when we filed suit. So, and I think if you have more of that continuing, then you might see a shift away from the re-exam. I mean, look, there's always been, in the past 6 or 7 years, there's been this waxing and waning of having re-exams going on at the same time as district court litigation. It used to be, you go back to the 2000, 2001, 2002 period, it never happened, right? And then suddenly in 2003, 2004, and 2005, everybody was doing it, either ex parte, mostly ex parte at that point, just because of the patents that were being litigated there. And then suddenly, those patents started getting out of re-exam successfully, especially in the ex parte process. And then the defense side woke up and said, whoa, what does it look like in litigation when the patent that you try to get re-examination on and have asked for it comes through and suddenly it's been reaffirmed as being valid? And so then after that, it waned a little bit, and then suddenly people realized, wow, it really does have an effect, either ex parte or more inter partes now. And so I think we're going to continue this waxing and waning process over the next, 5 to 10 years to see how it plays out and to see what the PTO does and to see what district courts do in response to it, which is why I feel very confident about my dollar.
Yeah.
Yeah, Rob.
What about this case that came down yesterday that involved ex parte re-exam? Do you think that because ex parte re-exam will still exist, it'll be in the CRU, whatever that looks like, and then you get to appeal it to the Patent Trial and Appeal Board and then to the Federal Circuit? Why would a defeated infringer not, if they could come up with really good art, not take a whack at the patent again through ex parte re-exam? Don't you think there'll be a rise in ex parte re-exams?
In fact, that's, I think, one of the consequences that could result, which is you actually might see a decrease in inter partes and then a rise again of ex parte that come along with it. I think that is potentially a result that you might see. And let me just, a couple on this point. At the very end of Rob's presentation, he raised 2 cases three, I guess, including the one we just talked about, but 2 others that came out in the past 30 to 60 days, the marine polymer and the Betcher case. I can't emphasize enough the immediate effect, at least of the marine polymer case in district court litigation. Immediately afterwards, within a matter of weeks, in virtually any single case where there was a pending re-exam, there was a motion in the district court on intervening rights to say that under marine polymer, there was an intervening rights issue across the board. None of those, they're too premature to say how those are going to fall out. But the fact that anything you say in re-examination, especially claim amendments, on dependent claims, even if you don't actually change the actual claim language, is having a tremendous impact in district court litigation virtually immediately. And how that plays out, what the Federal Circuit and maybe ultimately the Supreme Court does with it is really up in the air. And whether, for example, the re-exam has to be closed before marine polymer takes effect, even if you do a broad reading of it. But what if you say something in the first 6 months of re-exam, but it's still an open re-examination proceeding? Is there an intervening rights issue? And there are just a tremendous amount of questions that could be the subject of its own half-day CLE about the effect of marine polymer on it. I don't know if there's any comments about that. It's certainly something that we've seen.
I think for the defendant, I think it's really becomes a forum of choice issue, because what you're really looking at from the defendant's standpoint is, okay, now I have district court litigation or ITC litigation, and the other choice I have is going to the PTO for the various proceedings, and some of which, under the new regime, you would have the right to appeal. And it's really a question of your belief that based on the prior available, based on your invalidity argument, whether you have a better shot at the USPTO or at a district court, because taking the same argument to the district court, you still face the legal estoppel argument. So you can argue that there isn't a lot of difference between the two as far as the estoppel goes. But how PTO does in comparison with the very district court you are in, I think it's going to be a big motivating factor for defendants in terms of thinking about which form to go to, whether they should take a shot at the filing re-exams or other proceedings with the PTO.
And the differing claim construction point, this broadest reasonable construction versus what the district court does, is a real problem for marine polymer. I mean, it really is. The patentee is in the situation where you say something in front of the Article III court about what the patent means. Then you go to the PTO, and the PTO rejects what the district court has said and says it means something else. And then in response to what the PTO has said under some other different standard, those comments might be used against you to have intervening rights on the entire patent. And the failure to coordinate between the PTO and the district court is a huge problem here. And my plea to you would be that whatever the result here, that there be coordination between the district court and the PTO on what's going on, because the current process has the potential to be a mess given the different rules that are going on the district court side. Fair enough.
Yes, sir.
What are your thoughts on how this works in with a DJ action situation? You're faced with threat of lawsuit. You want to do both or one of them? What are your thoughts on that?
Yeah, let's see. I don't know if it's this slide, but when you do a DJ, you lose. I believe you lose the right to do an inter partes re-exam, and so you cannot do both. You have to make a choice, and I think that choice will depend primarily upon the issues that we're discussing here. What is your success rate going to be in the PTO versus what is your success rate potentially going to be in the district court? Obviously, you don't have the presumption of validity in the PTO that you do that the patentee has in the district court, which might affect it. But it depends really on I think some of the statistics that are going to bear themselves out over the next months and years about what's coming in.
Does the same thing apply to the PGR?
In the post-grant review, it's a little bit different. I think it is the same. Rob, do you know off the top of your head?
No, I don't think it does apply to the PGR. I'm not sure. I know that Joe Mattal was very concerned about this parallel universe. He was trying to shut it down. So the thinking was, if you're the accused infringer, you can't challenge it in court and also challenge it at the patent office at the same time. That was the thinking. I'm trying to think about PGR.
Yes.
It's in PGR.
You could still do non-infringement in the court and then do the validity downtown. So you still would do a DJ action. You just wouldn't do it on both validity and non-infringement.
Oh, that's right. That's right. Yes, you could not do it on validity in a district court, but you could do it on non-infringement. That's certain.
And I think on the issue of invalidity or even non-infringement, I think it really depends on what your defensive position is. For example, if your prior art under the patents issue under the old regime, if the prior art is not necessarily printed publication or patents, and prior is some other area that requires discovery or some other areas that such as on sale block prior use, or if one of your defensive positions under the new regime is the prior user rights, and I think the choice between utilizing the different proceedings will also be affected by your positions.
Judge.
Yeah, I just want to point out 325A1 is what prohibits you from doing the DJ that happens post-grant review. There's a similar provision in IPR, but IPR also has a provision about that lawsuit. Remember, once a lawsuit happens against you or charged with infringement, I can't remember the exact language, you have 1 year to file. That 1 year provision isn't in the PGR because you had to file within 9 months of issuance of the patent anyway. So there's similar provisions for DJ. The 1 year to filing is only going to be an IPR, which points up just one practice difference. Internally we've discussed, we imagine somebody will try to file a petition, which they then file the DJ action on afterward. You better make sure your petition's done right and have all the papers filed. And not get something that's defective. Because if you get a defective petition in the office and we aren't able to afford you a date, you've already filed an EJ action, you got a problem there. So just, if you're going to do that EJ action right after filing a petition, make sure your petition is as gold-plated as possible. As always, you would do with an angle.
On the opposite side of that question, if you forego the DJ and go proceed to the patent office, is there anything that stops the patent owner from bringing you into the forum if he wants to use and proceeding with a infringement suit?
I believe it would be stayed, but then it would just be subject to the general venue laws. Did everybody hear that question? I want to make sure I understand it, which is...
If the point is to avoid the dual track,
right.
does it only apply to the defense side and not sort of things?
No, so it's if you file suit after that, any litigation, someone will correct me if I'm wrong, but any litigation is stayed when the IPR, the PGR process is proceeding. Now, the district, the patentee can still try to pick its venue at that point, but subject to the venue transfer laws that would go along with it. Yes?
The patent holder file a post-grant review?
No.
Oh.
Give a new prior art 3 months after the fact, and you don't file it yourself.
No, I get you would probably want to use a supplemental review process.
Or an ex parte.
Or an ex parte review.
Or an ex parte re-exam. You can file an ex parte re-exam now for the patent. I mean, that was why ex parte re-exam was originally created.
I think
the statute for trials, all these proceedings are done by trials, so you need an opponent. So it's always a third-party petitioner. If the patent owner were to file it, we would deny it as not being a statutory requirement. It's a good point, though, and you're right, ex parte, the exam would be the potential. Supplemental examination would be the potential. So there are other avenues in the office, but the review proceedings would not be for these patents.
Right. But the ex parte re-exam would give you the opportunity for an interview at CRU if you're the patent owner.
I'll do another prediction here. We've discussed obviously the broad nature, especially the post-grant review, and that it's not just like an inter partes review. But one prediction, at least for non-practicing entities, my guess is if there really is an issue for non-practicing entities, they're just going to wait until the time to file the post-grant review has expired before filing their lawsuit. And once that has happened, look, again, as we discussed with Rob in the prior session, there very well might be some cases and some patents that a particular company is following very carefully and then institutes a post-grant review proceeding on those grounds. But oftentimes, probably the vast majority of times, that's not going to be the case. And sometimes the first notice that the defendant has of it is when they get the summons from the lawsuit. And if that has, that's after the post-grant review proceeding time, then this proceeding obviously wouldn't apply. Comments? Oh, sorry, one more thing here is that I think one of the things on the standard for initiation, it's more likely than not at least one claim. We talked about that. But also something that I think has an effect would be if there is an important or unsettled question of law. For example, if Bilski had come out the other way, could you file a proceeding that would affect all types of Bilski-type patents across the board, even if it is not more likely than not because it's an important or unsettled question of law to go with it. So there very well might be some test cases that some big defendants might bring to try to push the boundaries of the law that I think this certainly allows and encourages.
You know, one statistic that I was told by experts on opposition, your EPO opposition, is that something along the lines of 20% of all issued EPO cases are opposed. Yeah, 20%.
Those are really cheap proceedings.
Very cheap. Well, cheap to file the opposition notice, but you only have 9 months to pull the trigger. Which is why a lot of the Europeans are monitoring issuing EPO patents.
Yes.
Is the post-grant review process, from a legislative history standpoint, modeled after the EPO post-grant opposition process? Is it fair to look to what the experience of the Europeans is to imagine what they have here?
I don't know. I know that they were talking about opposition practice a lot when I was talking to them, but I don't think they were wedded to reproducing the European opposition process. I think their perception was that there were some serious problems with it, including the amount of time it takes currently.
Question in the back.
Jimmy?
Oh, sorry.
It's just that we can't hear back here when the conversation is.
Right, I'm sorry.
So if you speak up, it'd be very helpful back here.
My understanding, I wasn't there, but my understanding is our former chief judge and general counsel have gone over and talked about it. And there have been a lot of different things that were discussed. I mean, you could look at any opposition procedure that would include inter-party re-exam, ex-party re-exam, opposition, test case before the board. I mean, this was a wide open. They were looking at a lot of different aspects. So there wasn't just one. If you want to know, is it just purely meant to be based on opposition? The answer would be no. Is it based to be solely on inter-party re-exam? Correct. The answer would be no. But again, I wasn't there. That's just what's said out to me.
So we've talked a lot about the inter partes review already. Just a couple things to hit on this slide. First of all, theoretically, the estoppel standard has changed from raised or could have raised to raised or reasonably could have raised. Whatever that means, if it does make a difference, I'm not quite sure in practical effect whether it will have a real bite, but it is a change in the statutory language. We talked a little bit about the declaratory judgment aspect to it, where you cannot institute an inter partes review if the defendant has filed a declaratory judgment. This does not apply if the declaratory judgment is in response to a previously filed action. So to be clear, if you are the defendant and you've been charged with infringement, you can still do your counterclaim of or a declaratory judgment of non-infringement and invalidity, and you would still be able to file an inter partes review. And we've talked a little bit about this, which is the scope of the financial business method patents and what bite that's going to have and how that's going to affect litigation is still very much an unknown. And the pre-grant prior art submissions by third parties has some specific effects, and whether that's going to have an effect as well, again, I think is a little bit up in the air. On the estoppel provision, by the way, I do want to just hit, we talked about marine polymer, but on the Betcher case that also came out in the past couple months, that also is having a real effect in litigation, especially in multi-defendant cases, whether they're brought together in one action, which you could do before September 16th, or now post-September 16th in multiple actions. What happens if the same patentee sues multiple defendants and one of those defendants institutes an inter partes exam? What is going to be the effect, the estoppel effect? Is it what if they have a joint defense agreement? And what if it's multiple patents and some defendants do an inter partes review of some patents and some defendants do it of other patents? And so I think that how the estoppel plays out with respect to those situations is very much an unknown. I have my own personal opinions that if it's done in coordination that the estoppel provision should apply. But whether that plays out in practice, I think, is a little bit of a different story. Ming, did you have any comments on that?
I tend to think that for the legal estoppel to apply, some basic level of coordination might not be sufficient. It may take the parties in the same case to do some more, in terms of actively pursuing certain defenses as a joint effort. So I think arguing for the defendants, I would say that for the defendants who are not involved in those proceedings, it's hard to impose a legal estoppel on them, and it might not be an easier case for the plaintiff to argue that there is some sort of imputed knowledge or certain other types of legal estoppel against them. Okay, so I think quickly everyone knows about this already. Failure to obtain advice of counsel may not be used to prove willful infringement, and will become effective September 2012.
And now I think the other major effect from a litigation perspective on the law was a last-minute insertion in the bill in the House that banned multi-defendant lawsuits subject to certain restrictions. And you've already seen that effect both before it was signed into law and the run-up before September 16th, where there was just a whole swath of suits that named multiple defendants to get in under the buzzer before the law. And then after the law has taken effect, you've seen it from the number of filings and the number of cases that have happened where it's one plaintiff and one defendant, but they filed 8 to 10 lawsuits at the same time against multiple defendants, even though the same general theory of infringement might apply. I think for the most part, you've seen plaintiffs' lawyers be very careful about these provisions and have tried to err on the side of filing multiple lawsuits so that they aren't subject to the AIA provision on this point. But at a high level, this is what it requires, which is that the right to relief is asserted against, they can only be part of the same suit if right to relief is against the same parties jointly, severally, or in the alternative. That was still part of the old law. That mimics actually the federal rule on it. Arising out of the same transaction, occurrence, or series of transactions or occurrences. And actually that too is part of the old federal rule on this point. And then related to the making, using, importing into the U.S., offering for sale, selling of the same accused product or process. And so what I think the effect of that has been, people have seen it as, well, if it has to be really the same, it can't be just similar. It can't just, if Google and Oracle operate in the same way, generally speaking, if Google isn't using Oracle software, then it's probably not going to be seen as the same accused product or process. But what happens, for example, if you have a reseller? Is that going to count? Is that the same product or process? Or are there separate requirements that go into that? And of course, then the last one being questions of fact common to all accused infringers will arise, being what you need to do that. You can consolidate. It does allow consolidation of multiple actions, but only for pretrial purposes, not for trial. So the effect of this is potentially going to have the patentee will try validity as many times as the patentee names a different defendant with a different process or product in suit. And I think already you've seen different ways to try to get around this. You've seen people, for example, naming resellers as well that try to get more, having one company that has multiple products and trying to get in that way. You've seen just the naming of multiple defendants and how that plays out, whether it's going to cram the courts, and how district court judges are going to react to a whole new set of docket numbers that very well might inhibit the most efficient way to try the case is very much up in the air right now. Maine, do you have any comments on that?
And I think just in your comments about going after the resellers is an interesting one. And I think from MPE's standpoint, they're studying the impact of the new statute and they're thinking, okay, maybe I can go to separate companies like Dell and HP, but what if I name Costco plus Best Buy plus Amazon? They all sell the same products, and sometimes that is viewed as potentially a way to bring in the additional defendant and argue that you are well qualified under the statute because they do have the same products among the different parties.
And so again, it already is in effect, and so we are already seeing the expectation that it's going to reduce the number of defendants named in large suits. But I think actually already there has been accounted for that where some people are still naming multiple defendants just in multiple suits. I think there's still going to be a slight lessening in terms of the number of call it extortion cases that are being filed. But I think that that if you are trying to do a licensing and enforcement portfolio, your only choice is to file multiple suits. You're going to file multiple suits. Yeah.
Is equitable estoppel going to kick in at some point for a patentee who has litigated, these issues against different defendants and starts to establish a track pattern?
Or even legal estoppel?
You mean equitable estoppel in terms of tolling, or you mean in terms of collateral estoppel?
Collateral estoppel.
Okay. Yeah. Sure. I mean, that's the biggest risk, right? The biggest risk in all this, from the patentee's perspective, is in you have 11 separate trials where you prevail on validity, and then on the 12th you lose on validity, and then you're collaterally estopped. And if the other 11 aren't final judgments yet, you risk throwing those up into the air as well. So that's absolutely a huge concern. And whatever genius lobbyist on the defendant side thought of this provision was quite clever. Other comments or questions?
Yes. So I think Chico, earlier you talked about the prior commercial use, prior user right. I think this has been a very hot topic under the new regime, and this does allow companies who have been practicing certain commercial process or have been selling certain products to be able to come up with a defense when they were accused of infringement that covers something that they have been practicing more than 1 year before the patent was filed. So I think one thing to think about is does this create any imbalance between bigger corporations who tend to keep records pretty well versus smaller operations that, as Keith mentioned, might not necessarily be doing a really good job on keeping all the business record to prove this case. And I think this is why you can argue that under the new regime, because of the first inventor to file system, there may be or might be reduced need to keep relevant technical records. I think this does present a case where keeping your record can be very important. And I think another issue for another issue for a lot of future litigation is what does it mean to say commercial use? Is there a certain amount of threshold I have to meet before I can say that certain use is commercial? Is selling 10 samples to a company versus selling 500 samples or 500 products or versus 5 million products to different companies sufficient? And I think it's what I think an issue for a lot of future litigation. But from company standpoint, I think it's important to keep records so you preserve the possibility of raising the defense.
And quickly, you want to talk about patent marking, and we're about to wrap up pretty quickly.
Yeah, sure. So I think I tend to view this issue very differently. This, on the surface, it does make it a lot easier for people to mark their products. But I think I'm thinking, talking more for the defendants, I'm thinking about a lot of assertions by NPEs. NPEs, typically, they can go back, especially when asserting device patent, they usually are unable to go back and pursue past damages just because they rarely can force their licensee to mark their products consistently and systematically and continuously. But this does make patent marking a lot easier. And if you are a licensee settling with NPEs, I think this, compared to the traditional way of marking patent numbers on your products, it's a lot easier. But I think this also creates a lot of complications during the discovery, because basically you're talking about, for companies marking, it only has to produce its website records. And if the competitors are not necessarily the tracking their website records, it may be a very difficult case for the defendants to rebut, to argue that, well, in the past 6 years, you haven't been marking your patents. And it's the patentee who has the complete records about when they started marking their patent numbers and how they mark it and what patent numbers were listed on their website.
And briefly on false marking, they went away the day the act was signed, at least for the private attorney general right. There is still a private right of action if you are a bona fide competitor. But the effect of it has been to drop off a cliff the number of false marking cases. I think you're really only going to see false marking cases really in a competitor suit for some type of either trade secrets or unfair competition type act among competitors. So it applies without exception to pending cases on September 16th. And so you have to have suffered a competitive injury now to file.
Okay, so Justin is going to talk about some additional impacts, and I think we have talked about all the different complexities raised by the new regime. And as part of the concluding remark, I'm curious and find out from all of you, how many of you think that the new regime is going to reduce the cost of litigation? And how many of you think it's going to increase the cost of litigating cases and increase the cost of defending companies either by litigation or by USPTO proceedings? I see a lot of hands.
Yeah, and so just on litigation, I mean, are we going to see increased PDO activities? Will there be that significant cutback in multi-defendant cases? Are we going to see resellers sued more? Will we see a slightly greater risk in filing a declaratory judgment that may lead to an increase in licensing letters? Because if you file a declaratory judgment, right, you're giving up your inter partes or post-grant review right. And so that might encourage some more licensing for a lot of patentees who have resisted licensing only because of the threat of declaratory judgment. And I think going forward, I think one of the effects will be if we can encourage licensing in ways that inhibit declaratory judgments, you actually might, get some balance that avoids some of the costs and complexities that we've talked about today. And finally, are we going to see things move to the ITC where you avoid some of this? If you're going to have to litigate this in an Article 1 proceeding, maybe you try for that exclusion order if you can meet the criteria for the ITC. So these are all lots of the open questions, and there's really no right answer, but thanks for your time.
Thank you.
Thanks, Justin and Ming. We're going to have a part of our CLE today having to do with ethics. We have Rajiv Sadati from Perkins Coie. He's a partner there, and he's going to talk about ethics and your client's rush to file. Rajiv?
Thanks, Jim. So one thing with ethics, excuse me, is that not any one of us is an expert. We're all faced with these rules on a daily basis. Some of us understand it probably a little bit better than others, but I think this is going to be we're going to get more out of it if it's a collaborative discussion rather than just me lecturing to you, especially since I'm losing my voice already. So suppose a client, a longtime client, comes to you and they've been working on something brand new that could be their most valuable invention ever. And they're telling you that. Their marketing folks have a great opportunity. They want to get it out tomorrow. They need to disclose it. But they remember that you told them to file early based on the new law. But they weren't ready to file it before today. They want you to file an application the next day, even if just provisionally, based on the materials that they prepared for you. What are you going to do? So let's talk about a thought process that I think I would use, but maybe you guys have some other ideas. First is, do you have a conflict? So there's a rule up there on the conflict of interest. We're all aware of what a conflict of interest typically is. There's concurrent conflicts of interest, which exist if representation of one client will be directly adverse to another client. So may not happen here when you're filing a patent application, at least not at first blush. Or there's a significant risk that the representation of one or more clients will be materially limited by your responsibilities to another client, a former client, a third person, or your own interest. Even when there's no direct adverseness, this is a comment in the rules, a conflict of interest exists if there's a significant risk that your ability to consider, recommend, or carry out an appropriate course of action will be materially limited as a result of your other responsibilities or interests. So let's think about that for a second. So your client has come to you, they have a disclosure. What are the possible conflicts that could arise? Any answers out there? So think about this for a second. So they've come to you with the disclosure. You've got lots of other clients. What's a possible conflict? So we already had one analysis back there that the state doesn't consider your obligations under 1.56 to be an ethical requirement under the state laws. I think that varies by state. And if you remember, and I'm going to talk about imputation next, but if you're at a firm that has offices in other states, you might want to check to see whether other states have that obligation or have that ethical requirement. Second is, even if the state doesn't have such an ethical requirement, your malpractice carrier probably requires you to check a subject matter conflict anyway. So that's something else to check for. So if you have two applications for different clients that claim the same subject matter, or two applications for different clients with sufficiently similar subject matter that may obligate you to disclose one application or the other, or both, to the patent office as a result of your representation of one client, then that poses a potential conflict for you. So that's something to check for right away. So most of you already probably check for subject matter conflicts of interest. Is there anybody here who doesn't check for a subject matter conflict of interest when a new case comes in? Chico said and will admit it. So probably not. But what you want to make sure is you are doing this routinely. And how are you going to do it if a client comes to you today and says, file an application tomorrow? If you're a small firm, maybe you can get it done. If you're a larger firm, it typically takes you a little bit longer time. Most large firms will give attorneys 24, 48, or longer hours to figure out if there's a subject matter conflict of interest. So the second thing, I talked about this briefly a second ago, you have to make sure that you're checking across your firm. So a subject matter conflict of interest can arise even though you may not be aware of an application, somebody else in your firm may be. So make sure that you're checking with other attorneys at your firm to ensure that you're not filing an application that may conflict with somebody else's application. Some people believe that by filing a provisional application, you may not be obliged to make that Rule 1.56 disclosure. And that's probably true. So if a client comes to you and says, hey, I got to get this on file tomorrow, and it's going to be hard for you to tell them, especially if they're a long-time client, hey, I can't do this for you. But what you may want to do is file it provisionally, hope that there's no conflict of interest, but if there is, then refer it elsewhere later on and say, hey, I can't represent you on the non-provisional because I have a subject matter conflict of interest. Sorry. But we're going to talk about communications a little bit later. Second thing to check for is, are you qualified? So remember, this was an existing client, so you're probably working with them for a while, but this is a brand new invention, maybe in a different area, and maybe an area you're not familiar with. So what do the rules say? A lawyer shall provide competent representation to a client. Competent representation requires legal knowledge, skill, thoroughness, and preparation reasonably necessary for the representation. And if you look at what reasonably means, unfortunately it's a circular definition. At the bottom of the slide you see Rule 1.0 says reasonably when used in relation to conduct by a lawyer denotes the conduct of a reasonably prudent and competent lawyer. Very clear. So what would you do to make sure that you are competent? Maybe take a look at, is this in an area that you're familiar with? Are you able to provide sufficient guidance to the client before you file the application? Competent handling of this is a comment in the rules, competent handling of a particular matter includes inquiry into the analysis, into an analysis of the factual and legal elements of the problem and use of methods and procedures meeting the standards of competent practitioners. It also includes adequate preparation. The required attention and preparation are determined in part by what's at stake. So what are you going to be doing about that? You're going to take a look at this application. You're going to say, am I qualified to do this? Well, if it's a provisional that has to be filed tomorrow, are you going to be able to do that? Are you going to be able to read it in sufficient detail and say, hey, client, sorry, I think you should take this elsewhere. Hopefully that won't happen with a long-time client, but you may have to do that. But if it's one day, are you going to be able to make sure that there's adequate disclosure? And Keith probably talked to you about that earlier this morning. Is there going to be adequate disclosure in that provisional to make sure that you're filing a full provisional that they're going to be able to support their claims with later on? Keith.
A great example, I think, of what you're saying that is 101 right now with CyberSource. We have a series of cases. We really outline that subject matter. It's in a state of flux. I think the standard is higher now than it used to be because most of us go home at night. I'm on a number of listservs. I check the blogs. Wow, it's amazing. The case comes out within 2 hours. I have 10 or 15 colleagues that have commented on it. The standard is higher. And I would really look carefully at what you just put up to see, are we qualified and competent, particularly with regards to provisionals. Are we supposed to block diagrams in light of CyberSource and its progeny? Are we supposed to functional block diagram? What do we really need to claim? I don't know. It's challenging with the standard that we're getting on.
And you talked about disclosure this morning, right? I missed most of it. But so basically, your priority document, your provisional, is going to have to be a full disclosure. So you need to make sure that you're competent to know whether it's a full disclosure or not. One thing you could do is agree with the client that your representation for the purposes of filing that provisional application is limited. You're going to be able to say, or can you say, this is a question, can you say to the client, hey client, I've been working with you a long time, I understand your technology, but in this particular case, I may not be the best person suitable to file this provisional application for you, but because you're in such a crunch, I'm happy to do it, but here are the risks, and we're going to talk about what that communication needs to look like in a minute. Third question is, can you get it done? Rule 1.3 requires diligence. A lawyer shall act with reasonable diligence, again, reasonable is defined in a semicircular way, and promptness in representing the client. A lawyer's workload must be controlled so that each matter can be handled competently. So you already got a busy docket. You're busy today, you're busy tomorrow, and a client comes to you and says, we need to file this provisional with the full disclosure tomorrow. Do you have the time to do it? A lawyer's workload must be controlled so that each matter can be handled competently. That's something to think about. So one thing, as I mentioned in the previous slide, what you can do is try to limit your scope of representation. So the rules permit you to do that. A lawyer may limit the scope of representation if the limitation is reasonable, again that word, under the circumstances and the client gives informed consent. We're going to get to what that means in a second. The comments are, the scope of services to be provided by a lawyer may be limited by agreement with the client or by the terms under which the lawyer's services are made available to the client. I know you can all read this in just as well as I can, but it sort of gets us all to read it together and maybe understand it a little bit better. In addition, the terms upon which representation is undertaken may exclude specific means that might otherwise be used to accomplish the client's objectives. Such limitations may exclude actions that the client thinks are too costly or that the lawyer regards as repugnant or imprudent. So in this case, what would you do? You would say, client, I may not be competent to file this. Second, I don't have time to do as good of a job as I think you would want me to do. Maybe we can agree that given the limited time that we have to get this done, I'm going to go ahead and file this for you, but realize here are the risks. Risk 1, it may not be a full disclosure. Risk 2, I may not understand this well enough to make sure it's a full disclosure, and so on down the list. Although an agreement for a limited representation does not exempt a lawyer from the duty to provide competent representation, the limitation is a factor to be considered when determining the legal knowledge, skill, thoroughness, and preparation reasonably necessary for the representation. So this is going to come into play when, or if, hopefully not when, something goes wrong. You file the non-provisional, you realize at that time you don't have adequate support in your provisional. The client says, hey, I give you a whole day to figure this out. How come you didn't get it done for me? Something to fall back on, hopefully, if you have that representation limited and you have informed consent. So again, going back to communication, a lawyer shall explain a matter to the extent reasonably necessary, again, reasonable, to permit the client to make informed decisions regarding the representation. So you need to provide your client sufficient information to participate intelligently in decisions concerning the objectives of the representation and the means by which they are to be pursued, to the extent the client's willing and able to do so. So you need to educate them, make sure they understand the risks of what they're embarking on by coming to you at the 11th hour. Adequacy of communication depends in part on the kind of advice or assistance that's involved. So maybe what you might want to think about doing is preparing a form letter, because you know that after March 16th, 2013, you're going to have an onslaught of people coming to you saying, hey, I need to file this provisional patent application tomorrow. So prepare the form letter in advance that says, hey, client, thanks for coming to me. You realize we don't have much time to file this. Here's what I'm going to be able to do for you. Here's what I'm not going to be able to do for you. Please sign on the dotted line or send me an email to that regard. Anybody disagree? Okay. Disagree?
Well, not disagree, but just question how a court would view an attorney who said, I've only got a short amount of time, so I promise you that I can't do a good job. Can I go ahead anyway? I think it's...
So you mean a court when the patent is asserted or when they sue you for malpractice?
When they sue you for malpractice, yeah. So I see a jury saying this attorney weaseled out by saying the client approved of me knowing ahead of time I wasn't going to do a good job. I don't know. I would not like to be a defendant in that position.
So what's the alternative?
Decline representation. Sometimes you just have to say no.
Yeah, it may not be a client of yours very long either.
Well, whose best interest at heart here? Your pocketbook or the client? And if you don't have the time to do a good job, I would not take the case personally. I don't care what it does to my pocketbook. If I lost the client, goodbye. There's another one around the corner.
Yep, that's a fair point, but I'm sure there are also differing opinions. Keith seems to have one.
The point is that every client is going to have a certain, almost every invention is certain. Almost nobody can file sequentially and erase 2,000 different filaments that go into the other light bulb. This is a conundrum that we have to figure out how to solve as a group. Because we are going to face this repeatedly. We can't deny them all, or there'll be nobody to represent, there'll be no industry.
Another opinion.
Could it also be argued that using to help your client at the last minute when they would have no chance to go somewhere else is abandoning your duties to your client?
Especially if it's a long-term client, which was on the first line. I agree.
Rely on you after years and years.
That's right.
You being their only counsel.
Well, it doesn't have to be long-term. It just has to be a client.
An existing client.
This is only the second time he's still a client. Still got the
Good
same
point.
obligation.
Existing client, yeah.
Well, assuming the hypothetical that this is a long-term client and you've done lots of work with them before, is it malpractice, let's hypothesize, is it malpractice to not have counseled them before then? Why is it that they're coming to you literally one day before it's due? If they're a long-term client, like you work with them all the time, don't you know
Yeah.
it's a long-term client?
Right, but have you never had a client who's come to you today at the 11th hour?
Well,
It happens.
let me say, I'm not a patent lawyer.
Okay.
Right?
Yeah.
So there are, in corporate law, could still say, I mean, I just put it out to all of you who are patent holders. My gosh, if there is that hard and fast deadline that's coming up tomorrow, what on earth is the client doing coming to you 24 hours before the thing is due?
Yeah, it's off.
Sure. That's what they do.
Yeah.
That's fine. But here's the question. Isn't the question then, how does the profession then counsel the client not to do that?
Right. I think that's a good point. Unfortunately, clients have all sorts of demands, and sometimes their patent attorney or whoever's responsible for getting a patent application on file for the invention doesn't realize that there's a disclosure coming up. It's just like many business decisions. There's a lot happening, and somebody has to have the right set of information to pull the right trigger. And not all clients are able to do that all the time. And so that's why all the patent attorneys and agents in this room were laughing, because we see this happen to us quite frequently.
I think there are two things. One is, are you not going to take it because it's only one day, which is almost absurd, even if you have no other work to do, or is it because of other work demands? I mean, and that
We can't get that. What are you saying, start over?
I'm saying it depends on this is sort of a hard example because one day is really not enough time, even if we had no work going on. I think maybe a better example would be if you just had a month or 2 weeks, but you had a lot of other work going on.
Oh, but this is a realistic example. You're filing documents. I filed in Japan a year ago tomorrow. Please file it. I mean, this happens, if not once a month, at least twice a week. I mean, this is pretty common occurrence.
I'm not saying it doesn't happen. I guess what I'm saying is that in that case, I think that if you were to tell the client that you can do it, but you think this is not enough time to get it done, I think that would be a valid arrangement.
Yeah, I think as long as, and I don't know this from a malpractice perspective or an ethics perspective in terms of whether how a court would rule. But I think that if you're able to tell the client, look, this is unreasonable. You've come to me the day before it's due, and there's only so much I can do. I think courts would look favorably on that, as long as you've informed the client and you've counseled them, especially not to do it again. This happens, I'm sure, in Europe as well, where they already have a first-to-file system. Does anybody know what they do, what practitioners do in first-to-file jurisdictions today? What's that? There was a comment back there. Yeah. Right, but what happens, what do they do if somebody comes to them at the 11th hour? My guess is something similar to this. They say, there's only so much time. Was there a comment back there? Yeah.
We all already practice in the first-to-file jurisdiction because most of us have clients that work internationally. We do face this all the time. And you can't make negligence typically for their profession, whether that's medical or legal. I think it almost gets to what you do next. So your client comes in, they do this all the time, they're publishing tomorrow. To let them publish without filing and using absolute novelty on that subject matter would be malpractice. To file that and then follow up with subsequent filings that have better enabled disclosure and then bundle them all up into your utility and evolution filings is probably the way to go.
Right. Yeah, I think that's great. I think where I think it changes a little bit is the use of the word disclosure in the new statute. Until we know what that means, I think we're going to try to play it as safe as possible, but there's only so much we can do. There was another comment back on this side in the back somewhere. Yep. Right. That's what I was saying earlier, is you may not have enough time to make sure that it has the full disclosure the statute's going to require, that it's fully enabled and so on. Yeah. Great. Okay, so informed consent denotes the agreement by a person to a proposed course of conduct after the lawyer has communicated adequate information, so you need to figure out what that is, an explanation about the material risks of and reasonably available alternatives, which in this case there may not be many, to the proposed course of conduct. There's a comment relating to that. The lawyer must make reasonable efforts to ensure that the client or other person possesses information reasonably adequate to make an informed decision. Ordinarily, this will require communication that includes a disclosure of the facts and circumstances giving rise to the situation. Hey, client, you got 24 hours. Any explanation reasonably necessary to inform the client or other person of the material advantages and disadvantages of the proposed course of conduct, and a discussion of the client's or other person's options and alternatives. In some circumstances, it may be appropriate for a lawyer to advise a client or other person to seek the advice of other counsel. Hey, client, I can't do it for you. I have no time. I have these other obligations. Here's my friend Joe down the street. Maybe he can help you. So make sure your form letter is complete. Something else, I'm not sure if this is completely true or not, but something to think about. Can you charge more because the client's coming to you at the 11th hour? You're going to be dropping a bunch of work to do the work for this client. You may be giving up your night, your weekend, whatever. Can you charge additional fees? A lawyer shall not make an agreement for, charge, or collect an unreasonable fee or an unreasonable amount for expenses. The factors to be considered in determining the reasonableness of a fee include the following: the time limitation, and this is one of many factors, the time limitations imposed by the client or by the circumstances. Any thoughts on, are people going to be charging more? Do people charge more right now? It's kind of like a overtime fee. I mean, professionals typically don't charge overtime, but anyone doing that today? Nobody admits it? Okay. So it's a couple of resources, and I'll just touch on a couple other points right after this. So Washington State Bar Association has an ethics hotline. It's open during the week, but you typically leave a message and they call you back within a couple of days after they analyze the fact pattern, I think. There's also the Washington State website, which includes a full listing of the rules of ethics, the full comments from the standard RPCs, as well as Washington-specific comments. So useful site to look at. A couple of other possible traps, thanks to Keith, actually. One is NDAs. Contracts are interpreted under state statutes. Some states treat the words confidential information differently from trade secrets. When you're advising a client on NDAs, are you looking for things like that? Are you helping a client with an NDA that's going to be applied in a different state? Are you familiar with the laws of that state? Does your NDA have a choice of law provision? If it doesn't, in which state is it going to be contested? And are you familiar enough with the laws in whatever state is either stated in the NDA or not to know how it's going to be interpreted? So think about your NDAs. Anything else to add to that, Keith?
No, a lot of practitioners and all of that.
Second point. So we talked about this, I think, already today. We don't know exactly how it's going to be used. We're still required to disclose the best mode. It's not going to be something that the grounds for invalidation of a patent, but good idea to include it. So I'm going to break there. Any questions on this stuff, feel free to talk to me either now or send me an email. I'd like to thank all of the speakers for participating today. A lot of people came in from the East Coast to educate us, and we appreciate all of the hard work that everybody did. And even one of our local speakers had to fly all the way back from New York to give us a presentation today. So I'd like to applaud all of them for coming, and thank you for coming. Sydney, a couple of words?
Yep, I just have two quick announcements. Thank you all for coming. If you have your CLE course attendance report form, you can give that to me if you did not turn it into Linda already. And secondly, I know some of you missed the handout from Keith's presentation this morning. I have a couple extra copies of that. So I'll just be up here. If you want to give me the course, your attendance report, or get the presentation from this morning. Thank you all for coming. Perfect, thanks. Hey, Melissa. Hi, how are you?
Justin, come pay your dollar. Nobody wants it.
I'll take it back.
He would not eat the food that we want. Better that than the other one.
My court was. We'll be able to fix this again.
All right.
I do that. Some people in the world have brought Inequitable and explained it again to me. That's always fun. So who are you? Can I come to see you? They used to do searches. Yeah, no, we changed it in 90. I was the second name up until 90. And then Yeah, well, we had two. So people get very good presentation, man. Thank you very much. I got confidence. It's great because
I will mention to you the one page of didn't bring it where I really put them on. So we had a, I sued a patent so it's exactly a copy of it. They actually have reviewed the product, they modified the copy. Well, they modified it slightly, thought they changed the art, they didn't reduct it. But they were aware of our patent. The big summer product is dominating the field. So then they count and the patent they chose from the
Thank you for coming.
And it was the art that was I'm just in case. And they asserted that we did some of it. And I called the guy.
There isn't really.
I said the case, the product.
I think your facts are valid here.
This is a rule that this is a rule that come on. He says, I just have to get it.
What about just
I mean, his point.
Oh, really? Okay.
He says, I can't go. We alleged. He said, you alleged that I could post.
Oh, so you went to...
No, actually, he said, you alleged that. He says, I can't go for the judgment. It's so much but so I would just point out the unfairness of trial. Why they get it?
Same building, this is like such.
Yeah,
he's always
I will. Yeah, that's rule 11. I've had dozens.
Yeah, it's a very, very interesting process. Always very.
And in fact, the matter is, most district judges look askance at the guy who reads the rule 11, not the guy that observes it. How often do you brought a rule 11? Well, that's very much. People are not that inequitable. I agree. An inequitable conduct claim is a patent. It puts the patent attorney out of business. I can have a. No, of course. In fact, it's a attack on your integrity with rule rather than yeah. And so, you know, Because it's not treated with the,
really
tender care of the Rule 11.
ever happen. So that's why.
Trial lawyers should not do this.
So bad.
Get to argue before the patent office. Well, it's an, well, but no, actually, I'm not sure that's necessary. I agree with everything you said going in and out. No, they were unrelated. All I know is that every time somebody had our patent, we have a big toast and say, here's the monopolies. Here's the barriers to entry. We have a toast now. Here's the barriers to entry. I threw mine in. Oh, you're waiting for his.
And what happened was I really satisfied. Yeah, it happened 2 weeks ago. 18. But the weird thing is, I'm sitting down.
All right.
You're putting the stress on me.
But yeah, but it's
Oh, good.
maybe
Yeah.
I have
Yeah. Yeah.
everybody keeps saying, I'm in the doctor yet. I haven't done that.
Okay, we'll see.
Hey, Jim. Nice to meet you.
Has anybody ever commented?
Those who are very active.
But did they know what it was?
The only people who comment on it are people who know.
They would just hear the first half.
You'll make this fun. You went,
My husband had one.
you went, right answer.
She said,
Right answer.
she says, she says, I'll call them. So her husband, she says, I've got one. So I know what it is. Give one. No, it's true.
So were you involved in the event at So now
Yeah, okay, well, maybe next meeting.
Yeah.
I go there more than you might think.
So who's not flying back with you right away?
Yeah, see,
They can get some of these things together for
I do a lot of stuff.
This whole right now?
Yeah.
See, I was there. You gave the talk here.
Not going to New York.
I don't know actually. I trademarked something I have to. That's Microsoft.
We're hoping that we just need
So it's we have a lot of big ones. And this whole it just
otherwise
It is.
I was down with
And I don't believe people would
When is the, when are you going to give us
So you're
it's very weird.
Robert, are you heading back with you?
I try to avoid spending overnight, but
Okay. No, we're just saying if you slow down, especially the other counties.
it's really
Well, thanks again.
Sure, thanks for coming.
Yeah, just find a trash.
We'll take care of it.
Okay, well, listen, Justin. The one thing, thank you so much.
So he's going to join us tonight?
Oh, well, you're heading to the airport?
No, I'm going to do.
Oh, right.
Rob's heading to me.
Okay.
Hey, Justin, are you joining us or no?
No, I think Justin is saying.
Justin!
Justin?
Justin! Are you joining us?
I
I'm going to talk to Rob for 5 minutes.
Okay.
And then I'm going to try. Where are you going to be?
We don't know yet.
Okay, well, shoot me an email. I'm going to try. I might try to find you, but I got to get home at some point.
Okay. All right, we'll let you know.
What are your thoughts?
I live here.
Yeah, so we're just riding with you?
Yeah.
And how about you?
Not till 11 o'clock.
Oh, okay. Mom is, so where are you from?
Just a Spokane.
So what is your, do you have a technical background? Yeah, electrical engineering and mechanical. So I do a lot of smartphones, conductors, software, it's all over the place.
Okay, well, you're saying the key is electrical.
It's interesting, and I think the fact that there has been so much going on, so that electronic products, stuff that really make but I think 2 years ago, even on pick up the game, but I've been talking to people about AIA, part of it maybe knew us with the conquest finally getting able to get out this forward. Part of it because he was concerned about overly aggressive and what I've been talking to other as well. We need to be really careful about not losing the house. One day you'll come with a system. Yeah, if everybody has to file on copy of what they have with their custody. But the reality is so it's going to be an adjustment period. Yeah, and the adjustment, like I said, period is going to be about 20 years. Yeah, long. Yeah, 21 years of your slide. Yeah, and it's interesting. I mean, people tend to think that under the new statutes, things actually allow you to come to the but just based on the audience, just until you figure out all of it, because there's two registers. Yeah. You don't know
Hi. Hey, Justin Nelson.
So maybe we can use these guys. 3 of them have to go to the airport after. So I thought if we go to what's that lounge under Wild Ginger? Triple door? Yeah. So we can go to Triple Door. You guys can just take the train from there to the airport. Instead of take the cab from.
I think I'm the passenger.
Right, okay.
I just got an email that I can get on the 7:30
okay.
block, so I'm going to get it, but maybe I'll catch up with you guys next time.
Okay. All right, so it's all dwindling already.
Yeah. Sorry about that. Yeah, no, it's Friday night. Thanks so much.
Sure. Well, thanks for coming. Thanks for being available.
Maybe next time I'll go see you in town.
Yeah. We have an office in Taipei.
Yeah, I heard about it. Tom was telling me about it. I had a call with him 3 weeks ago.
Oh, yeah? Okay.
I guess many of you will be traveling. And in fact, and we're sharing this. Ryan,
Ryan.
David Farr, and several others are based in they're asserting the
these things become.
there's a lot of folks
Thanks for coming over. I'll try to make out. Technically, I'll be on vacation.
So you do a lot of software
Software prosecution, yeah, some litigation.
No, I won't post that because otherwise I
Primarily,
really have
prosecution side of things, analysis.
and most of the IT people are here in Seattle.
No, we have people all over. So most of our patent litigators are actually
Yeah, no, I think it's pretty common now.
it's called Brown and Bain.
Yeah, Brown and Bain, because it was interesting. I'm drawing a blank on the guy's name, but I was involved in the case in 2008, and I think that's around the time that your Brown and Bain office, one of the attorneys there was the opposing counsel, and I noticed that they changed. And I was calling Tony and said, hey, we're now opposing counsel. You guys just merged it.
Yeah, it's so a lot of people there. We have a San Diego office there as well, which has a bunch of them. Some litigators, not a huge practice, but the Silver or Palo Alto office.
That's pretty good. I think.
Well, it just moved from that for mountain reviews.
But that wasn't established yet.
Palo Alto or mountain review? Palo Alto, maybe a year ago? Year, less than 2 years.
Or San Francisco.
Yeah, but the people in that Palo Alto, like I said, they were just up 101. Down a bit.
Oh, have you visited Taipei office already?
Not yet.
Are you going here?
Well, I'm actually flying through Taipei in 2 weeks, but
where are you going?
India. So I'm flying through Taipei to India. You're going to India. This will be my 4th trip in 12 months.
We have people who are really active in India.
Oh, okay, cool.
Could talk.
What kind of work?
And then I don't know exactly sort of the type of work that they're.
Would IP or business?
IP. Yeah, mostly like, I don't think there is mostly yeah, and then Sherman.
Okay.
It's done. Yeah, they are two. Yeah, I traveled to Taipei a lot. I think I made about 6 to 8 trips but it's fun. It's vibrant.
Yeah.
I'm sure.
Yeah, it's growing fast. A lot of companies.
So you do IP, you develop IP work there, or there's a lot of corporate and other areas.
It's a little bit of both. It's people with needs over there, and we work with local counsel there.
Oh, okay.
People with needs in the U.S.
Oh, good. Yeah, you serve both needs in one trip.
That's right. We try it. Yeah.
All right. Thanks so much. Very nice to meet you.
Likewise.
Take care.
Bye.
Bye. So what do you think? I think we're pretty good. People had some good comments. Now we have to
people that I talk to, on the whole, everybody's pretty much said, yeah, well, it's complicated, and it's time to start thinking about it.
You guys think the plans are still working the old system requirement? No. For those of us that have to sit down and advise on strategy, I totally shut up. We're about. We are trying to find balance of the size of all that. It's really clear. There's like a rule that's there's, we did. When I was doing the whole thing, years ago, this is how we do things. Michael, how are you going to do things? How are you going to show your strength? Is this going to give you, are you losing all your rights that you might invest in?
Future things is